Thursday morning. We have to record this one. It's the first time we're teaching this lesson, so hopefully you should all be good at that. Let's see if I can just get this thing going. Whoops, mine's got stuck. Oh, here we go. So it is federal real estate laws. It's a 2-hour core class, just to remind you of those rules again. Have your name displayed on the screen, of course. Keep your video turned on, and obviously be in attendance for the whole of the class, and be seen and engaged. We'll try and chat with each other as we go through this class today, and I'll submit 3 keywords. This is one of our other dogs, one of our Bernie dogs. That's Rosie. When she pops up, we'll show you the keywords and they'll flash on the screen. I won't be responding to chat. Leslie will respond to chat, but please just unmute and chime in if you have anything to say, because I can't see everybody. I only see a few pictures when I'm running a full screen, which I'll run throughout the class. So just unmute and chime in. I'd like to have your thoughts and your comments, your stories, your questions, and between us, hopefully we can learn something today on this 2-hour core class. So we'll try and cover the following in the next couple of hours. We'll look at the federal fair housing laws. We'll look at Americans with disabilities, that's the ADA. And we've got the equal credit opportunity platform we'll look at truth in lending, which is the Regulation Z, and Real Estate Settlement Procedure Act. We'll also look at the Sherman Antitrust Act and the Uniform Commercial Code, which is the UCC, Environmental Protection Agency. We'll finish up with the Do Not Call law. So we'll try and cover those in the next couple of hours and see how we go. So first of all, we'll just open up real estate transactions. Of course, all real estate transactions are governed by federal statutes and combination of common law and state law, which can vary from state to state. Obviously, we're in Utah and we follow the state law. Real estate brokers, in fact, we do have another, the companion class to this is next Thursday, and that is on Utah real estate law. So that's the companion one to this one, and we'll look at the Utah law on that one. Real estate brokers are employed as the agent of the seller to obtain a buyer for their property. We all know that. Listing agreement, of course, is written contract between the broker and the seller. Salespersons, brokers, and principal brokers are licensed and regulated by the local state laws. An agreement between the buyer and the seller of real estate is governed by the general principles of contract law. A contract is a legally enforceable agreement between 2 or more parties, where each has a legal obligation that must be completed. So that's what we're trying to do here. Property in the United States, well, of course, we have the contract, it's a legally binding agreement, defining and governing rights and duties between 2 parties, enforceable when it meets the requirements applicable to the law. Some of you may recognize this little image. That's Tisha, the Lady of Justice. Anybody here previously or work in the Justice Department? They'll be familiar with this. Let's have a look at this little image and see what we can learn from it. Anybody know what the sword represents? We've got 3 parts actually to this image: the sword, the scales, and the blindfold. Anybody know what the sword might represent? Well, represents state authority. The scales represent an objective standard. And of course, the blindfold represents impartiality. So let's look at those 3 areas and see if we can learn something with regards to our part when we are operating as real estate agents. So, sword and authority, there it is. As a realtor, we all have authority. We're licensed professionals. We obviously represent our brokerage, and we are members of the National Association of Realtors. We are also connected with the Utah Department of Commerce Division of Real Estate, and we are a member of a board, like the Salt Lake Board of Realtors or Cash Valley, or whichever board we're a member of. So we have some authority here, and when we look at that sword, that is the part of the image that refers to our authority to operate as licensed professionals. Any questions on that? Are we all good? I'm just giving you some background information as we get tucked into this class here. We've got the scales. Of course, these represent objective standards. So we're going to keep to the federal and the Utah state laws, contracts and agreements. Full disclosure from us from our behalf and on behalf of our brokerage and our clients to the other party. So that's what our part of the scales represents. Of course, the blindfold represents impartiality. So we are not going to discriminate against anybody. We're going to be totally free to include everyone. And my machine has just lost the internet connection. Or it did come in eventually. There it is. Did come in eventually. Everybody's entitled. That's everybody we deal with is entitled to be treated exactly the same, with the same respect, importance, value, and courtesy. So when you look at that blindfold, that's what we're representing. We are going to be treating everybody without any discrimination. That brings us up to our first keyword early on in this class, and we'll pull that one up. And here it is. You can imagine what this one will be. Of course, discriminant will be the first keyword. So jot that little word down. It should be flashing on your screen. D-I-S-C-R-I-M-I-N-A-T-E, discriminant.
And I did share the link in the chat. If you hover along the bottom, you see an icon that says chat, and that is in the chat. I will share it again at the end. I know some of you like to fill it out as we go along, others like to do it at the end. So
yeah. I do like to get these hours banked for you quickly, so you do them immediately after the meeting and get you all banked, and we can all get those credit hours. So discriminant will be your first keyword. Okay, I will not mention that again, and we cannot share that in the chat again. And have any problems with that down the track, talk to Leslie Ann. All right, so let's have a little look at the property law in real estate. So various forms of ownership. Of course, we're familiar with these. We've got the land, and hopefully some of us have had an opportunity to represent people buying or selling land. We've got buildings, generally commercial buildings we're talking about there. And then we've also got personal property, which probably most of us are involved in. But they're the various forms of ownership when we're talking about property law in the US. Right, so let's have a look and see if we can dig down in some of these federal fair housing laws. We'll look at the first federal housing law in 1866. We'll then look at the Civil Rights Act of 1968. We'll go through the amendment, which is in 1988, discrimination against the handicapped, and of course the accessibility and adaptability laws, the buildings, and the penalties and risk reduction. So let's have a little look at those, see if we can learn something. So you're probably all familiar with that date. If you are familiar with the federal fair housing laws, it's 1866, and basically right after the end of the Civil War, that's between 1861 and 1865. In 1866, the United States Congress passed the Civil Rights Act. This law essentially prohibits discrimination in the purchase, sale, lease, or conveyance of real property on the basis of race or color. So that's when it kind of started. It was a bit vague in those days. So it did get sort of toughened up a little bit down the track. This act prohibits race discrimination only, and there were no exceptions. Unfortunately, the wording was a little bit vague, and therefore in many circumstances was quite difficult to enforce. So that's why they had to kind of work on this and toughen it up a little bit. I'll put some of the codes up there. You'll see that Silcrow, that's that kind of double S. That gives you the section. If you go to the 42 US code, you'll find, when you go down to that Silcrow, you'll find, as noted at the bottom there, you can find out where this information comes from. So all citizens of the United States shall have the same right in every territory as is enjoyed by white citizens, therefore to inherit, purchase, lease, sell, hold, and convey real and personal property. Okay, so that was in about 1982. So it's a few years after it started. And then we move forward to 1968, where we get the Title VIII public law. This was signed into law in the United States on April 11th, 1968 by President Lyndon B. Johnson. And it was a landmark law. Put a note down there. Landmark laws establish precedents that determine significant new legal principles or concepts, or otherwise affecting the interpretation of existing laws. So this was a landmark law. The Civil Rights Act in 1968, under the direction of the Department of the Housing and Urban Development, that's the HUD, you probably recognize that phrase. This act was administered by the Office of Equal Opportunity, which is referred to as the OEO. Civil Rights Act made it unlawful to discriminate based on any of the following. You'll recognize these first five, which is your race, your color, religion, sex, and national origins. That's kind of where we started on this. These first five were pulled into action in 1968. And then we find that the protection on these basically were as follows: refuse to sell, rent, or negotiate, altering terms of the, that should be for the rental agreements, that should be 4 in there. Advertising that excludes certain groups of people or organizations, denying the right to inspect, steering customers or clients away from certain areas for discrimination, block busting, which is called panic peddling because of an increase of ethnic or minority groups moving into the area, and redlining, that's lenders refusing to give loans to certain populated areas. Let's break there for a moment and just have a pause and look at some of these areas and see if any of us have come across any areas of concern in transactions where we've had to deal with some of these areas of protection. Anybody got any stories or comments on anything we said so far? Okay, has anybody here heard of panic peddling before? Okay, good. And redlining it used to be quite popular in the probably a couple of decades ago, where lenders were refusing to give loans and they had to toughen up on that one. This act did come out in 1968. It did take some time in order for this to kind of, filter through the system and make sure everybody was on the right path. But even today, sometimes we can get folk that are not quite aware of their responsibility in this area. So it's good that we know about it. So then we move forward to 1988 and we get a bit of an amendment. We get these extra 2 items that come in, which is your familial status and your disability. So let's have a quick look at those two. So familial status, you cannot discriminate on the basis of familial status, children under the age of 18 or anyone who is handicapped. A person who is handicapped is described as physical or mental impairment, which limits one or more major life activities. This does not include someone who abuses controlled substances. Anybody had any challenges or any experience where they've had to deal with this with a transaction? Okay. Disability, of course, you cannot refuse to make modifications or exceptions if such changes are necessary to provide for full enjoyment. For example, wider corridors for wheelchair access, places to include pets, for those that need help with the blind, like that little image there with that dog with his spectacles on, and anything that we need to do to accommodate, particularly in rented accommodation, we need to be able to do that. Nobody is discriminated because of a disability. Anybody dealt with some transactions where they've dealt with the blind or dealt with someone disabled and they've had some little hurdles to cover as they've gone through our transaction?
In regards to the disability, I believe there are some guidelines as to what modifications are required to be made and those which are somewhat discretionary. I don't remember what those were though.
Yes, you are right there. It is Paul, isn't it? I can't quite see it, Paul. I think it was you that was speaking. Yeah, there are some modifications. You need to make sure you're aware of those when you're moving into a transaction. And usually this is to do with rented accommodations. It's not so much to do with buying general residential real estate, because people are looking at the houses that are going to fit their needs. And if they need to make some moderate modifications, they'll probably do that when they've bought the house, or as they're in negotiation with the seller. But there are some general rules that pathways have to be wide enough, doors have to be wide enough to get wheelchairs in. But certainly for the rented accommodation, you need to be squeaky clean on this. Heights of tables and access to facilities, etc., needs to be applied by. Any other comments on that, Paul?
Just that Edge Homes does a decent job of having at least one of their condo units of every building is an ADA one on the bottom floor.
Yeah, very good. And these days they have got some of the general rules with the steps and the rails, and having rails, whatever it is, 18 inches above the ground, you've got to make sure you have rails on that. So they have got some general rules for all properties, but as Amber said, there are some of the builders these days who have extended some of those extra benefits to accommodate more people that may have some disability. We had a client a few years ago who was, they're actually deaf. So as we went through the transaction, we had the daughter with us throughout the process. And as we went through the contracts, she would be signing for her parents. It took a little bit longer, but it was quite an experience. It was a good experience to work with someone that could not hear. And that's about the only one we've had. Has anybody else had any experience working with people with different types of disability that you actually sort of change the style in which you work with them?
I had a person who was in a wheelchair that we had to carry upstairs and stuff. The husband normally had a really good way of doing it, but it was always interesting because every house I had to scope out before and make sure that there was a way for her to even get there in the first place.
Perfect, yeah. And also if you're working with someone that does have a disability, whether it's physical or mental, you just need to make sure you've got a little bit more time in the process. And as Amber said, scope out the platforms beforehand so you're ahead of the race and you're not surprised when you go to a home that you can't get them around the home. But being forewarned is being forearmed in these areas. Anybody else got any stories on this they'd like to share with how they've overcome some challenges that they may have had with people with disability? What about language skills? Language is another one. Oh, did someone chime in then?
I've got a question, Stephen.
Remy, how are you doing?
It is good to see you, sir. Always a pleasure. It's been a minute. Yep. Happy New Year, brother. Happy New Year.
You too. Yeah, great to see you. I can't see you actually, Remy. I can hear your great voice.
Okay.
Yeah,
quick question. It's been a minute since of course the real estate training, going through the real estate licensing process. Who is responsible to pay for modifications if they are required? In other words, someone wants to buy a home, and a ramp is required for them to be able to get, into the home. I don't remember what the rules were. If there are some modifications to be made, is a buyer responsible for those, costs? And the seller just has to be open and of course accommodating to allow those to be made, or I don't remember what the rules were.
Yeah, so as long as the seller has the home that meets all of the standard requirements and rules and regulations, which obviously inspectors are familiar with, they're good to go. If there's some extra things that are needed, like maybe an extra ramp that's needed, or maybe there's a stair lift that's needed, which is going to be extra, then obviously the buyer would be responsible for that. And sometimes they can work out an agreement as they're going through the contract to add that work in as they go through the transaction. But it would be the buyer's responsibility to add those extra items to the sale, if that makes sense, or the purchase. Has anybody had any instances where they've had to deal with a client that has been in that situation, who's wanted a stair lift put in, or a ramp, or some modifications to the home? No, okay. But my understanding is as long as the home meets all of the other standard requirements, any extra items will be purchased by the buyer. Is that helpful, Raimi?
Absolutely. I just a brief experience. Recently, one of my listings had, it's a big two-story home with a basement, etc. We had a buyer that wanted to put an elevator in this home. Of course, the home does not have an elevator. It's a pretty tall, beautiful home, but the buyer was considering putting an elevator, and of course, it was their choice to explore that possibility. And we ended up accepting a different offer because the sellers didn't want to tie up their home until the architects figured out how to do this, etc. But they were willing to look at an elevator. Yeah,
and of course, if you're in that situation, the seller generally would like some, non-refundable earnest money, because obviously, if they're making these adjustments, for some reason the transaction doesn't run to close, then they may have a house that they can't sell as easy because it may have some modifications in which may not be as attractive to other buyers. So just be aware of that. If you have got a seller, then maybe there'll be whatever it may cost to be that non-refundable earnest money to help. Very good. Let's move on, shall we? So basically, the discrimination in the housing based upon race, colour, religion, sex, national origin, familial status, and disability prohibits discrimination by direct providers of housing, such as landlords, real estate companies, as well as other entities, such as municipalities, banks, and other lending institutions, and homeowners insurance companies whose discriminative parties make housing unavailable to such persons. So that's why you'll find, lots of wide corridors and open spaces to be able to take care of that need. Let's go into these just a little bit detail. I'm picking this basically right off the rules. So I've not created this language, it's the language off the rules, okay? And so if we run through these, it might be helpful just to understand a little bit more about what we're talking about here. One of the central objectives of the Fair Housing Act, when Congress enacted it in 1968, was to prohibit race discrimination in sales and rentals of housing. Sometimes housing providers have tried to disguise their discrimination by giving false information about the availability of housing, either saying that nothing was available or steering home seekers to certain areas based on race. Individuals who receive such false information or misdirection may have no knowledge that they have been victims of discrimination. The Department of Fair Housing seeks to uncover such kind of hidden discrimination and hold those responsible accountable. I've not seen this happen. I don't know if anybody else has seen this happen at all in recent years, but apparently this was a challenge in the earlier years where they were trying to steer certain groups of people away from estates. Has anybody seen that happen, or got any stories they want to share that they've noted in previous years where they've seen an example of this? Okay, let's look at the discrimination in housing based upon religion. We learned the following. Fair Housing Act prohibits discrimination in housing based upon religion. Whoops, what happened there? I lost my, there it is. This provision covers instances of overt discrimination against members of a particular religion, as well, or as well less direct actions. So such as zoning ordinances designed to limit the use of private homes as places of worship. The Act does not, the Act does contain a limited exception that allows non-commercial housing operated by religious organisations to reserve such housing to persons of that same religion. So that's where the exception is on that one. Then we've got the discrimination in housing based upon sex, including sexual harassment. The Fair Housing Act makes it unlawful to discriminate in housing on the basis of sex. Women particularly, those who are poor and with limited housing options, often feel little recourse, should not tolerate the humiliation and degradation of sexual harassment or risk having their families and themselves removed from their homes. Departments and enforcement program is aimed at landlords who create an untenable living environment by demanding sexual favours from tenants or by creating a sexual hostile environment for them. Such tenants who have been treated unfairly by a landlord because of sex and also deter other potential abusers cannot continue their conduct without facing repercussions. In addition, pricing discrimination in mortgage lending may also adversely affect women, particularly minority women. This type of discrimination is unlawful under both the Fair Housing Act and Equal Credit Opportunity Act. Has anybody had any situations or stories that they are aware of where this has been a challenge? No?
I
So
had
maybe-
yes, yes, it's Ashley. Hello.
Ashley, hello, Ashley.
Hi. Mine's a pretty simple example, and this was many years ago before I knew better, but I think a lot of times we get ourselves, well, we put ourselves into potential, violation of the federal fair housing laws without really even knowing it. I remember I was selling a home in Pleasant Grove, and in the description on the MLS, I had put that it was that you could see the Pleasant Grove Temple, from the home. And I got a message from the MLS that that could be seen as violating these laws. And so I had to remove it. But, thinking back, I remember reading that a lot on MLS descriptions, and a lot of things that people write could get them in trouble. So that was just one small example that I ran into.
That's a great example. And when we're describing a property, it is a good idea not to include, I guess, religious buildings that may be close by or, a scenic view for the property. So I'm glad you highlighted that, because that certainly is something to be careful. Of course, it might be good for some folk, it might not be good for other folks. So we need to try and be neutral as best we possibly can. Very good. Any other comments or thoughts on that slide?
Oh, this is Brett. I was just going to add to that to say I think the best thing to do when you've got a property that might have a great view of a religious building. I think you do aerial photography and regular photography, and you let the views speak for themselves.
Very good. Yeah, and certainly we've done that where we've had large homes. Particularly, we've always done drone footage, so that people can see the area, they can see how the neighbourhood is created, and they can see everything there. And you're absolutely right, Brett. You don't have to talk about whether a religious building is good or bad, because it's just there for them to figure out for themselves if they want to live in that area. So very, very good. There was someone else who also commented. I heard. Who was that?
Yeah, and I had a reverse situation where a client was coming as a transplant from California, and besides having room to put their motorhome, their second largest concern was the saturation of the majority religion in our state. And I had to go backwards on that and help guide them tenderly and which areas would have a higher saturation than others.
Right, very good. How did that pan out for you?
Well, I'm actually a general contractor. I build homes. Most of my business is building, and just a little bit of it is real estate to help my own self. They actually bought one of my houses next door to my own home, so it worked out fine.
Oh, perfect.
And they're okay with me being of the predominant religion, and they found the state to be extremely open and welcoming in the area, and they're glad they did it. So
Very good. Excellent. Some
Hey,
good
hey,
stories there.
Stephen, I just remembered an example I had.
Perfect.
So it was kind of interesting. I had a couple clients that were openly gay, and I was helping them shop homes, and things were going just fine, and as far as I knew. And then they had a home that they couldn't qualify for. We had them under contract, and the lender kind of dropped the ball on them, and they became very disgruntled that they weren't able to buy that home. And so they did put up some complaints, kind of throwing in there as well that this idea that there might have been some sexual harassment. Well, what was interesting is based on their complaints, we said, okay, well, if you want, we'll switch you to another realtor within Presidio. And we found another realtor that we thought would be a better fit for them. And this realtor made mention to them on the phone that she was also gay. So you can see where this is going. It got really interesting when they put up a complaint about that realtor for saying that she was gay. So it was, I don't know how that all pans out with the fair housing, but it was kind of funny. So I think that probably the lesson from all that, and I never said anything, that I thought was discriminatory. But I guess the lesson to all that is, even if they are openly telling you things, I guess you have to be careful never to share that with anyone.
Yeah, that's a very good example, that is, Brett. We just got to be neutral, that we're on nobody's side. Whichever the platform is, we just have to be total, because we don't know how people are going to use whatever information we share or mention, and it could be used against us. So be very careful. Just while we're still on this particular screen, has anyone had any difficult situations where they're showing a home on their own to a member of the opposite sex, and that there has been any sensitive issues that they had to be careful of? Anybody had an experience on that? No? Okay, well, we're good then. Anybody want to comment on that? What do we need to be careful of, particularly you ladies? No, nobody's got any thoughts on that. I thought it might.
I mean, I've done it before. I've had I'm not single. I've had a married guy who always wanted to drive in the car with me. And we did that. I just always carry.
You always carry what? I miss what you carry, Amber.
Oh, I carry a concealed carry gun.
Okay.
But I wasn't really worried about him, especially after about the 6th or 7th time. And there was many times that the wife would come with us. But there's a lot of times that she'd be working and he wanted to go see something. And so, but you carry pepper spray, you can carry a bunch of different stuff, and your safety should be number one over anything else.
Yeah, definitely be careful. So you just got to be careful when you're one-on-one, because you don't have any other witness with you on, if you're accused of something. So just be aware of that. And in real estate, we have to be as squeaky clean as we possibly can. Any other comments on that?
Let me just make a quick comment about buyers wanting to see only homes within a small specific area, and that just makes me nervous when I get a request to get them hot sheets or listings that are only on the east side. They don't want to see anything else. my approach has been to simply tell them, look, we've got Salt Lake County, we've got Utah County. There are numerous areas, including the area of interest for you. I'm going to set you up to get listings from the county, and then you pick which ones interest you. But I'm not just going to send you listings only in Draper, because you don't want to see anything on the west side. You don't want to see anything else. That's a real interesting position that some clients put agents in only wanting to see, homes in only one area.
And yet the flip side to that is irritating the client with extra information that they clearly didn't want.
Yeah.
Yes.
We're working for the client, and we have got to do our best to give them what they're asking for. So yeah, we've got to get the balance right. And right across the board here, if we can see that a client is trying to hone into a particular area and we think it may be discriminative or against discriminative laws, then we do our best to open up that gate as wide as we possibly can so that we can't ever be challenged on that. Very good. Thanks, Deanne and Remy, for sharing that. We'll go on to the section on national origin. So the Fair Housing Act. If I'll get someone else, why don't you read this one for me, Remy, and give people a chance to listen to your lovely voice and have a break from the British accent here.
No. Okay. Federal fair housing laws, the Fair Housing Act, discrimination in housing based upon national origin. Put on my glasses here. The Fair Housing Act prohibits discrimination based upon national origin. Such discrimination can be based either upon the country of an individual's birth or where his or her ancestors originated. Census data indicate that the Hispanic population is the fastest growing segment of our nation's population. The Justice Department has taken enforcement action against municipal governments that have tried to reduce or limit the number of Hispanic families that may live in their communities. Lenders have been sued under both the Fair Housing Act and the Equal Credit Opportunity Act when they have imposed more stringent underwriting standards on home loans or made loans on less favorable terms for Hispanic borrowers. The department has also sued lenders for discrimination against Native Americans.
Thank you, Remy. You got such a nice reading voice. I couldn't resist that one. So there we have the discrimination housing based upon national origin. Has anybody had any encounter of any transactional clients that had to deal with this? Anybody, or know of any stories where an agent has had some challenges working with this area?
This is the only one that I've actually ever had to report to the what is it? Real estate.
The division?
The division. This is the only one and that Jen got to help me with. It was really exciting. No, just I had a Hungarian client actually with a very thick accent. And the listing agent, we were basically buying her own condo that she'd been renting in. And the listing agent was the landlord. And he had been mistreating her for a long time. And he would make horrible comments about her, the smell of her place, which typically just smelled like her typical food from Hungary. He would threaten to throw her out constantly. Even while we were under contract buying the place, he said that something that she had misspoken, which was really just a thick accent issue, was going to kick her out on the street, so she'd never live in a house again. And I think part of it was because he did know her and had just been racist against her basically the whole time, which is why we were trying to buy the place so that she wouldn't have to deal with him anymore. It was just a really exciting, fun time.
Well, thank you for sharing that, Amber. Yeah, so we obviously still have some of this happening today. And we just got to be careful. And if it does cross our pathway, then obviously we work with our broker and we try and do as much as we can to tidy it up. Any other comments on that?
How did the story end, Amber? What happened?
He ended up with the house. We got it done, although I ended up reporting him, but Jen held off until we closed so that we make sure we had no problems with the actual deal, since he had basically full, I don't know, the original owner of the house had died. So the family had basically given him attorney privileges or whatever what that's called, signing rights. Anyway, so we closed the deal, got her the house, and then Jen reported him. So I don't really know how it happened after he got reported. We just reported him and she ended up with her house. But we ended up multiple times pushing out, because there were holes in her house he was unwilling to fix and all sorts of stuff. So we had to fight a little bit, but we were as careful as we possibly could so that she would still end up with her house and not be kicked out of it, which we still would have reported him had that happened. It just would not have been pleasant for my client in the meantime.
Right.
Yeah, very good, very good. And you noticed the use of the words careful, and that's what we have to be, because we're trying to balance this and make sure, our clients are getting what they need, but also we do need to report things. If something comes across our pathway and we know it is wrong, then we do have a responsibility to report it and not just to turn a blind eye. Let's go on the disability, and may have someone else read this for me. We got not heard from yet. What about Erin? How would you like to read this one for me? I'll load it in.
Okay, so we have federal fair housing laws, the Fair Housing Act, discrimination in housing based upon disability. The Fair Housing Act prohibits discrimination on the basis of disability in all types of housing transactions. The Act defines persons with a disability to mean those individuals with mental or physical impairments that substantially limit one or more major life activities. The term mental or physical impairment may include conditions such as blindness, hearing impairment, mobility impairment, HIV infection, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disability, head injury, and mental illness. The term major life activity may include seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. The Fair Housing Act affords no protections to individuals with or without disabilities who present a direct threat to the persons or property of others. Another area is ensuring that newly constructed multifamily housing is built in accordance with the Fair Housing Act's accessibility requirements so that it is accessible to and usable by people with disabilities, and in particular, those who use wheelchairs.
Wonderful. What a great reading voice you've got, Erin. Thank you very much. There's a lot of juice in that little comment there. Has anybody had any clients that may have fallen in some of these unusual areas that are mentioned here?
If I can comment, my mom is actually in a wheelchair, and so we had to move them out of a split level home into a 55 plus condo without stairs and wider hallways, and it comes a little tricky when you got to find something accessible for wheelchairs. So this one kind of rings near and dear because I mean, for a seller to try and make things accessible as possible is really appreciative for those of us dealing with those with disabilities.
Perfect. Thanks for sharing that, Erin. Very good. Any other comments or thoughts on that slide? Okay. Let's go for the group homes. So let's see if I can get someone else to read. Oh, sure. I have to involve everybody, you see. What about Josh? Are you still with us? I can't see everybody. I only have a list here. Josh, are you able to unmute and help us on this one? Could you read that one for us?
Yeah, you bet.
Thank you.
Discrimination in housing based upon disability group homes. Some individuals with disabilities may live together in congregate living arrangements, often referred to as group homes. The Fair Housing Act prohibits municipalities and other local governments entities from making zoning or land use decisions or implementing land use policies that excludes or otherwise discriminate against individuals with disabilities. The Fair Housing Act makes it unlawful to utilize land use policies or actions that treat groups of persons with disabilities less favorably than other groups of non-disabled persons. To take action against or deny a permit for a home because of the disability of individuals who live or would live there. To refuse to make reasonable accommodations in land use and zoning policies and procedures where such accommodations may be necessary to afford persons or groups of persons with disabilities an equal opportunity to use and enjoy housing.
Perfect. Thank you, Josh. Great read. Anybody got any comments or questions on that? I know we just kind of extended a little bit from the previous slide there.
I don't know. There's probably some of you that know the story of there's a certain multi-million-dollar house that couldn't get sold because it was a multi-million-dollar house with very specific uses. So it ended up getting sold to a group home, and the HOA, which now has been dissolved, tried to sue to stop it from turning into a group home in their neighborhood, because obviously it was a luxury neighborhood and they were afraid of what that would do. And now they're being sued back because they lost, because you can't discriminate against the group home. And honestly, I don't think it's a very higher end group home type situation. So I don't think it really detracted from the neighborhood at all. And you cannot tell if you didn't know that that's what it is now. But it became a giant lawsuit that one of my friend agent brokers, she was actually the one who was selling it. So on her end, she was fine. It's the neighbors that were a little bit mad about it, but they didn't win.
That's a great story, that is, because that's usually the platform we have concern on, is where you've got a large home and it's converted to a group home. Very good, great story there, and thanks for sharing. A few things on new construction. Who'd like to read this one for me? Who we've not heard from today? Let's see. What about Cindy? Would you like to unmute and read this one for us?
Hi, Stephen.
How you doing?
Good. How are you? Federal Housing
Good, thank you.
Act. Discrimination in housing based upon disability. Accessibility features for new construction. The Fair Housing Act defines discrimination in housing against persons with disabilities to include a failure to design and construct certain new multifamily dwellings so that they are accessible to and usable by persons with disabilities, and particularly people who use wheelchairs. The Act requires all newly constructed multifamily dwellings of 4 or more units intended for first occupancy after March 13th, 1991, to have certain features: an accessible entrance on an accessible route, accessible common and public use areas, doors sufficiently wide to accommodate wheelchairs, accessible routes into and through each dwelling, light switches, electrical outlets, and thermostats in accessible locations, reinforcements in bathroom walls to accommodate grab bar installations, and usable kitchen and bathrooms configured so that a wheelchair can maneuver around the space. Developers, builders, owners, and architects responsible for the design or construction of new multifamily housing may be held liable under the Fair Housing Act if their buildings fail to meet these design requirements.
Very good. Thank you so much, Cindy, for reading that for us. And going back to Ramey's first question early on, you'll find that the new construction, the builders, I think each year are having to just up their game a little bit to make properties a little bit more comfortable for particularly those with certain disabilities. So you're probably going to see that continuing as we go from year to year. Houses built this year will probably have some more upgrades than the ones that were built last year. Okay, anybody else got any comments on that slide?
Yes,
Fire away.
probably about 10 years ago, I had a realization from a friend of mine who, unfortunately, his father-in-law fell and broke his hip.
Oh,
And they had a 2-story home. And what happened was they actually had to set up a bedroom in the living room so that there was a place for him to sleep and move around a little bit. He did have a wheelchair after the surgery, but the second floor was totally unable for him to maneuver within that level because the doorways were 30-inch doorways. And I'm an architect from years ago, probably 40 years ago, and still maintain it. And I do building. And all of the homes that I have built all have 36-inch wide doors. And I'm just wondering how long it's going to take for architects and builders, and I'm sure we have another builder here, who would make 36-inch doors a requirement in all the homes, not just because an individual is handicapped or disabled for a long period of time or a short period of time, but just for those particular instances. They're not ADA requirements, but I'm just kind of wondering, I'm sure soon that will occur. And I don't know how many of you have had clients who look for 36-inch wide doors with that kind of thought in mind.
yeah, very good, Paul.
I know from building, I actually did a custom for an elderly grandma a couple of years ago, and we needed to make it wheelchair accessible for her. It is code that your hallways can't be less than 36 inches, so that part's already covered. And a wheelchair, most of them actually will fit through either it is tight through a 32, but easily through a 34-inch doorway. And so if you are dealing with people in a wheelchair, it may not be called out as ADA because that would be a 36-inch doorway, but a 32 and a 34 still works, depending on the size of the wheelchair.
Yeah, and you notice in this little slide here, we're also talking about switches and controls that must be reachable from a wheelchair. You'll find that those
Even, hey, this is Cindy, and I just wanted to make a quick comment. Pocket doors work really well as in homes or any kind of dwellings that I don't think a lot of people realize, like, oh, the doorway can be wide enough, but if you don't have the door set up properly, a person in a wheelchair can't even get in. They can get in there, but they can't even turn around, or they can't even maneuver once they're in there. Sometimes those pocket doors work really well. My husband is in a wheelchair. We built our house back in 1996. We had a custom builder do it for us. It worked out awesome. We're not looking at moving or selling, but we have a couple of pocket doors in our house that have made the maneuvering of his wheelchair to work really nice for us.
Oh, great comment. Thank you, Cindy. Very good. Let's move on. Buildings, adult-only apartments and or complexes are not allowed. So, I think we're all familiar with that. Exceptions would be for those areas of accommodation that are just for the elderly. Prevention. So, keep accurate records, establish safe and systematic procedures, use objective criteria in selecting properties, allow customer to set their limits, provide choices and variety. Violations, of course, fines, and obviously our license is at risk. So there we have that. Look at the ADA, still on disabilities. There's quite a chunk on this, so I thought we'd roll through it, make sure we understand it fully. America's Disabilities Act prohibits discrimination against people with disabilities in several areas, including employment, transportation, public accommodations, communications, access to state or local government programs and services. As it relates to employment, Title I of the ADA protects the rights of both employees and job seekers. The ADA also establishes requirements for telecommunication related services. Title IV, which is regulated by the Federal Communications Commission, also requires closed captioning of federal funded public service announcements. And that's the site you would go to if you wanted to have any more detail on that, which is www.ada.gov. That brings us up to our next keyword, halfway through this class today. Thanks for your involvement and your good stories and comments. This one will be disabilities. So it's a number 2 keyword, disabilities, D-I-S-A-B-I-L-I-T-I-E-S, should be shouting at you on the screen there. Jot that down. That first keyword I can't give you again, but it also did begin with a D. And this is another D word, disability. So that'll be the second keyword for this class.
I love your dog.
You do? That's Rosie,
Yep.
that is. She's a Bernese mountain dog, and she's a lot of fun. We have 2 of them actually, Rosie and Bella. They're both sisters, and the Bernese dogs are very, very gentle giants. That's what they are, gentle
Very
giants. Thank you. Let's look at the Equal Credit Opportunity Act. I'm not sure if any of you have come across this before. Let's see if we have a different reader. Who hasn't spoke today? Let's see on my list here. Heather, are you still with us? I've got you down on my list here. Would you mind reading that one for me?
Sure, I can do that.
How are you
Prohibits
today?
creditors. I'm good, thank you.
Good. Thank you for being with us today.
Thank you for doing this. Okay, so the Equal Credit Opportunity Act prohibits creditors from discriminating against credit applicants on the basis of race, color, religion, national origin, sex, marital status, age, because an applicant receives income from a public assistance program, or because an applicant has in good faith exercised any right under the Consumer Credit Protection Act.
Perfect. Anybody come across this at all? Any challenges with this or any stories we can relate? Usually our lenders are pretty sharp in this area, so I don't think we generally get much of a problem. So basically it's illegal to discriminate on age or marital status in granting credit. Lenders cannot make an oral or written statement which might discourage people from making an application. Lender cannot inquire about child care problems or child care support payments unless it's given voluntary. And Utah Fair Housing Law prohibits discrimination in lending based on the source of funds, such as public assistance. So just good for us to know that. But I think over the past few years, maybe over the last decade or so, the lenders have become pretty sharp in this area. And I've not encountered any challenges with credit opportunities for clients. I don't know if anybody has here or anybody would like to comment on that slide, or if anybody has any stories. No, pretty good. Okay.
The only comment I have is I loved you reading marital status with your British accent. That was very nice.
Sorry about that.
No, I loved it.
I get them muddled up sometimes. It's status, isn't it? Status over here and status where I'm from. I'm a bit of a muddled person when it comes to the language. So thank you for at least liking my accent on that.
No,
another one I get caught up sometime is, what is it? It's just gone. There's another word that's a similar challenge for me. It'll come back to me soon. I don't know if you ever used this form. It is available on the utahrealestate.com site. It's the credit report contingency agency to a real estate purchase contract. I've never used it before, but it is there if someone needed to use it. Has anybody used this before? You probably don't even know it's there, but it is there. And basically, it clearly says, if you note, it says, the buyer authorizes the seller to obtain at seller's expense a credit report from the Consumer Credit Bureau, and is to use the report in evaluating the credit worthiness of the buyer. For a note to be taken back by the seller from the buyer in this transaction, if in the seller's sole discretion, the report is unsatisfactory, seller shall so notify the buyer on or before whatever the date is. So if you did come across a situation you wanted to use such a form, it does exist, and that's what it's called. And it's very simple, and obviously it would be part of the real estate purchase contract.
I can't really see
Anybody?
that would help you win an offer ever.
Sorry, Amber, I missed that. You cut out of it. Just run with that one more time.
I just said, I can't really see how this would actually help you win an offer ever.
Right. Yeah. And that's
Especially
probably
with
why we use it.
The pre-qual letter and the pre-approval letters have already scoured that.
Yeah, you're right. And I wondered why it was there, but it is there. And I have no idea why we would need to use it, particularly as you've got the pre-approval letter anyway. So the lender's already done that check. I don't know if anybody here has ever had use of this or know of how it might be used.
Just possibly, could this be related to a seller financing deal? Where,
Good point.
right? I mean, where the seller's actually funding the purchase and perhaps might require this, maybe.
That's a great answer. That is, I've not thought about that, but seller financing certainly could be needing this form. Very good. Thank you for that. So we're always learning, always learn from each other. And there we have it. So there it is. If you need to find it, you can just pop onto the site there, and it's in the library of forms. All right, let's get on to this one. And Deanna, this is another one I really have a problem with, because we always call that Regulation Z, of course, but over here it's Regulation Z. And it's taken me years to call the letter Z by pronouncing the letter as Z.
Well,
Have you noticed?
to clarify, we hope you never ever lose that charm, so don't try.
Have you noticed that all of the other letters in the alphabet we call by the name of the letter, right? So, you know, if it's letter H, you say H, you don't say letter H or letter A, B, or S. But when you get to the Z or the Z, you call it the Z because it's actually the sound of the letter. So I've never figured that out. I did do some research though and figured out that most likely it's because it rhymes in the alphabet rhyme. Z, I think, rhymes with me or something. So anyway, this is Regulation Z, or from the Englishman here, Regulation Z. Truth in lending. Who can tell me what truth in lending is? This is a big topic in the 2007, 8, and 9 time. Who can give me an idea of why we have the truth in lending? Just a summary. Anybody know?
Well, it's the kind of lending is kind of a deceptive practice if you think about it.
Yeah.
There's different rates and things of that nature, the fees that all apply that you can have built into the loan, or you can have it separated from the loan, and what qualifies you for a loan rate and things of that nature. So basically the law this was brought out to actually identify all of those things so the consumer better understands what they're paying for.
Perfect, Paul. Why don't you stay on, Paul, and just read that for me?
Okay, federal law designed to promote and inform the use of consumer credit, called the Consumer Credit Protection Act of 1968, also known as the Truth in Lending Act, TILA of 1968, of which Regulation Z is part of. All disclosures are required about the term and cost of the loan to standardize how borrowing costs are calculated and disclosed. The TILA also gives consumers the right to cancel certain credit transactions that involve a lien or the consumer's principal dwelling, regardless of certain credit card practices, and provides the means for fair and timely resolution of credit billing disputes.
Perfect. Thanks so much, Paul, for running through that copy for us. So truth in lending is a big thing now, and our loan companies are all over this. They got licenses they've got to keep up to date, just as we have. and they've got to make sure they're squeaky clean on this. So price of home mortgages, of course, equity homes, that's your, your remortgage or your second mortgage, your reverse mortgages, obviously your credit card installment loans and other student loans. Lenders are required to provide borrowers with mortgage. Lenders are prohibited from using unfair practices that might give to a conflict of interest between the lender and the mortgage broker. Access to, of course, interest rates, monthly billing statements, notice in writing of fees and finance charges, notify in writing when there is a charge of interest rate on variable rate, and of course receive fair and timely responses to billing disputes. So truth in lending, very important, and I do feel that we've probably cleaned out a lot of the grey areas on the lending platform since the 2007, 8 and 9 challenge we had. Okay, anybody heard about this one before? The Real Estate Settlement Procedure Act. Anybody heard of that one before? This is an unusual one. So, the Real Estate Settlement Procedure Act of 1974, the RESPA. The Act requires lenders, mortgage brokers, or servicers of home loans to provide borrowers with pertinent and timely disclosures regarding the nature and costs of the real estate settlement process. And usually this is all taken care of by our lenders anyway, but that's what it is. Anybody heard of the Sherman Antitrust Act of 1890? There he is, Mr. Sherman. Anybody heard of this one before? Okay. United States antitrust law, which prescribes the rule of free competition among those engaged in commerce, passed by Congress and named for Senator John Sherman, who was its principal author. So that's also part of our real estate information, believe it or not. What about this one? Anybody heard of Uniform Commercial Code, the UCC? Nope. Okay. I've got you some visuals at the bottom there, which can remind you what this means. First published in 1952, Uniform Commercial Code is one of a number of uniform acts that have been established as law with an objective of harmonizing the laws of sales and other commercial transactions across the United States, including all states, District of Columbia, and the territories of United States. For example, goods may be manufactured in one state, warehoused in another state, sold from a different state, and delivered in another state. So that's what that act is all about. And I presume the reason it's part of some of the real estate federal law is that it's allowing us to cross-sale real estate in different states. Any comments or questions on that? Okay, let's go for this one. Environmental Protection Agency. So United States Environmental Protection Agency. And this is what the objective is. Americans have clean air, land and water. Wonderful. National efforts to reduce environmental risks based on best available scientific information. Federal laws protecting human health and the environment are administered and enforced fairly. Environmental stewardship is integral to US policies concerning natural resources, human health, economic growth, energy, transport, agriculture, industry, international trade. All parts of societies, communities, individuals, businesses, state, local, tribal governments have access to accurate information sufficient to effectively participate in managing human health and environmental risks. Contaminated lands and toxic sites are to be cleaned up by potential responsible parties, revitalized. Chemicals in the marketplace are reviewed for safety. So let's pause there for a moment. Has anybody had any experience, had a transaction, maybe they're buying or selling some land, and they've found that there are some areas that need to be tidied up when it comes to the Environment Protection Agency?
Well, there's a lot happening with meth. Is it that solid?
Very good.
Yeah.
Yeah. Go ahead, Deanna.
We had a friend buy a condo, and it was for her daughter, and the daughter kept getting more and more sick and is actually still very, very almost terminally ill. And they found meth in the neighboring unit. And they ended up selling the unit. It had to be totally cleaned up, and it was on their dime. So it's kind of really a hard thing to navigate as far as who's going to cover the damages.
Is it progressing? Where are you on that transaction?
Well, so the condo was resold after it was cleaned up, and another layer of protection between the units was installed. And then there was a test. So to resell it, there had to be a test proving that the test came back negative.
Okay. Very good. How do you think we work with clients who have no idea of, the importance of environmental protection? Obviously, the inspectors always offer those extra services, the termites and the meth, the radon. How are we best to advise our clients when we're moving into an area that may have some concerns?
Just advise them that it's a wise investment to have those tests done, and not just think everything is wonderful, because visually everything is wonderful. And
right.
And especially in multi-unit housing.
And often in multi-unit housing, it's more difficult to clean up, more complicated to clean up, because you're dealing with other people in that unit. So yeah, we need to be aware of this. There's obviously a strong act here. We're trying to protect human health, and that number 3 there, it really says, that's what we're trying to do here. We're trying to make sure that, the health of the human is looked after, and the environment is taken care of as best we can. What about land? Because land can sometimes be very, very difficult to navigate, particularly if it's land that has, I don't know, maybe not been used for a long time. How do we work with that? Anybody had any experience of working with selling land that may have some challenges?
It's best if you are selling it, and also if you're buying it, to make sure that there's a soils test that is accompanied and attached onto the listing. And that soils test will indicate whether or not what kind of depth you'll find compactable soil, and also if there's any contaminants in the soil. And if there's contamination, what will the remedy be? As far as you can have it hauled off, it's just rather expensive.
Yeah, and if you look at the disclosures for the land, so like a 3-page document, you've got the soil tests on there. They are clearly outlined, and it's important, if we are representing the seller, that ideally they know what they're working with, so there's no surprises. I mean, obviously the buyer, a smart buyer, is going to make sure that they review the property or the land based on their evaluation. But it's good if the seller knows what they are working with, because that may change how they market the property or what sort of price they're looking at.
And if you're representing the buyer, we need to be aware that in our Wasatch Front area, and also along the Uinta Mountains, for lands that are going to be used for a cabin or any other kind of home, there's a lot of people that put in fill, and it looks like it's buildable, but you have to go down to the virgin soil. And so it's something to be aware of for your buyers, that just because it looks flat and they can build it there doesn't mean they can. So there needs to be extra due diligence on that.
Yeah, we had a piece of land. We sold quite a few pieces of land in our early days, and we had one a few years ago. And it seemed to be like one of the last pieces or last lots in this little, sort of area. And as Deanna said, the builders just kept dumping their soil on there. And this was quite a large piece of land, And at the back, there was a drop, a strong drop of, I would say, I'm thinking say like 50 foot maybe, down to a pathway. So there was some that you couldn't really use, but it was a great scenic view. And we had 2 or 3 different very strong buyers look at it. And they did their soil test, and you had to go down, I think it was 8 or 10 foot before you'd even get to the start of that virgin soil. And I think the land sold, back in my mind, I was thinking it might have been 100 and, I don't know, 30, 40, 50 grand or something. But the people that actually bought this property, they spent close to $200,000 actually excavating this land. That's included the time before they started to build, and then after they build, they excavated, you know, sort of stepping stones all the way down. They had like
Was the purchase negotiated to help compensate for that?
A little bit, yes. They did come down in price. I think they came down probably, I don't know, 30 grand or so, but it was nothing like the amount of money that was needed to prepare this land for the build. I mean, you know, the people that bought it, they liked the land and they were happy to pay the price for the land and spend the extra money to make it work. But you're absolutely right, Deanna, that a regular builder just would not touch it unless there was significant time going down to that virgin soil.
And also be aware that it's not just fill that's the problem, but also like in a mountain lot, that you can't build on slough off that is topsoil. I'm just
That's
working
right.
on a project right now. We're having to haul out 6 feet of topsoil to get down to compactable soil. So things that if you're as an agent, you can really help your buyer avoid a lot of problems if you're getting those tests done ahead of time.
I have
Yeah.
a quick comment about land.
Yeah, fire away.
I helped a buyer a couple of years ago purchase a half acre in Plain City, where the seller did disclose that about the first 20 feet of section of the property, she said there was gravel and unknown stuff there. And she accompanied us on our inspection and everything. Well, come to find out, when my kids, and they were just young kids too, were building their house, the digger, the excavator guy, the whole lot was unusable except for maybe like the last 20 feet of it. She had been dumping stuff in it and it was going to cost thousands. They ended up suing her. And after about 1.5 years through the court systems, my guys won. But what a hassle. But that's because she lied on the disclosure. She disclosed that there was some unknown stuff, but she showed us that it was only a short part of the property when it was pretty much all of the property.
Yeah, and Stacey, that's a really good story because it shows that you can't get out of this if you're dishonest from the outset, and the buyer comes in and finds you know that you were dishonest. They can still sue you. They can still sue you multiple years down the track. It doesn't have to be within a certain period of time. So it's really important when we're working with disclosures that we encourage our clients to disclose everything, however small it is, because it keeps them clean and it will stop you know, anybody trying to sue them. Good story, that one.
I just
Go
wanted
ahead.
I just wanted to make a quick comment. Some of you are certainly a lot more familiar than I am with a huge cleanup that's taking place in the Daybreak area. Here in Daybreak, you know, I've got a client that is you know, building a lovely home west of the Mountain View corridor. You know, I mean, just all sorts of homes are going west of Mountain View corridor in Daybreak, and you know, there was a huge. I think the term is a super fun cleanup, huge cleanup there. That's you know, of course, required as you know, as a result of the mining or other things that were, you know, dumped on the land west of here. So that's something just to be aware of. The Daybreak HOA does do a good job informing buyers about, through all their documents about that issue, but it is an issue here.
Does that impact resale in that area? For, you say the HOA is disposing it, what happens if one of those homes is resold?
Yeah, sure. I mean, resale is unaffected because the cleaning, because the cleanup was quite thorough, quite substantial. The federal government was involved. So there's been untold millions spent to clean up that area. So any new build is of course approved, and it meets all the required standards.
But in spite of those standards and all the work done, have you personally found any hesitancies from buyers?
No, none.
Okay.
None. My wife and I, we live here in Daybreak, and there's been no, just no effect on property values. If I've got a listing here that's closing in a couple of weeks. It is unaffected because the cleanup again was just so meticulously done. But it is something just to be aware of. That the soil has had contamination over decades of mining here in the area.
Yeah, well, Daybreak's one of those areas that they've completely transformed that, which looked like unusable wasteland,
right?
To it's like a little city now, isn't it? That's very well maintained. But that's obviously why you pay a good HOA subscription each month, but they are obviously using it wisely, which is a good thing. Very good. Anybody got any experience with radon? That's another topic that comes up often when we're talking about environmental protection. Anybody like to talk about experience with radon?
That's becoming more and more common, and there's actually a map, and it shows the areas that are more susceptible to high levels of radon and on the Wasatch Front, and you can access that and see if the home that you're dealing with is falling in that red area to start with, and then go through testing after that. And the challenge with the testing is that test has to be put into a room in the basement where it's not going to be disturbed, and yet you can't guarantee that the seller isn't going to disturb it.
Yeah, some of the challenges have been when they've opened the window, or they've had multiple doors open, they've got more air moving down there, and it does adjust the results. So yeah, you have to be very careful with the radon testing. Make sure you've got a good relationship with the agent. If you're representing the buyer, make sure your listing agent can help the seller be cautious to make sure.
On the contract side of that, if the test comes back very high, what have all of you found as far as how to remediate? I mean, it can be remediated. There are companies that do that, but who would be the likely person to pay for that?
It's going to be the buyer.
The buyer would? Okay.
Yeah. It's going to be the buyer that's
And if I've got a high enough number, I can get the seller to normally work it into the contract somewhere. But
yeah, sometimes you can
negotiate. At 3.6 and my buyer's freaking out, then I'm never going to advocate for the seller to be paying for that.
Yeah, if it's a high reading, the buyer will say, hey, we've done the test on this. We are concerned it's high. We have got to now spend some money, to move these fumes out. Can we renegotiate the price? And then, of course, those two parties can work that out. So you're absolutely right. But ultimately, the seller doesn't have to adjust anything because they're selling the property as is. And I've had a few clients that have, on both sides of the aisle on this, both selling and where radon has been a challenge, and usually you can work it all out. But I remember one client said, well, it's not been a problem for us. We lived here for whatever years, and it's been fine. And of course, that doesn't help the buyer. And of course, with radon, you can have one house that may have a challenge with it, and the house next door may not have a challenge. You know, properties next to each other may be affected differently. It
And
just
you can
depends how
explain, you can explain to the buyers too, that that's impacted on how airtight the home is. And that in Utah, we like to make them airtight to keep in our heat and our cooling, but that actually also makes it a little more aggressive towards the radon. And so when you say one home rates differently than the other one with the lower rate may be more leaky. And sometimes that's not a bad thing.
Could be, yeah, could be. But it also could be that there may be no radon just underneath that house. But some people do have some very sensitive health requirements, and they can't, if they're living in the basement, they can't live in there with high radon fumes. It is a fairly easy remedy to fix though. And most houses have got, particularly the new houses, have got a space that's been left where you can put the pipe, you know, the tube all the way from the basement out to the top of the roof and get rid of those fumes. Anybody else got any thoughts on?
I found that builders are, I work with new building, and a lot of builders, at least some that I've dealt with, are just putting them in their homes just at the get-go.
Yeah, just put the pipe, yeah, the tube in there. Very good. Good, okay. Let's spend a bit of time on this one, because this has been something that has caught our attention over the last few years. Anybody know what the National Do Not Call law is? Anybody familiar with this? There must be someone here that's familiar with this law.
I feel like it doesn't work.
You get too many calls in yourself. I know that.
Yeah.
Keep blocking them. Okay, so Federal Fair Commission Consumer Information, that's where you're going to go. And if you need to have some information on that, you'll go to that website. However, you have got to watch out for they call it the TCPA, which is the Telephone Consumer Protection Act. I don't think those of us who are working individually probably have a problem with this, but I'm going to give you some information on this that might be helpful if it does come across your pathway. And I'm just, oh, here we are. We got our third keyword in here. So let's just put that on the screen. Do not will be the third keyword phrase. D-O-N-O-T, do not. There we go, do not. So if you missed the other two, talk to Leslie Ann. I can't say them again, but they did begin with a D, I tell you that. But that's the third one, do not. So, real estate agents must comply with the National Do Not Call rules. All right, anyone who has placed their number on the Do Not Call list or registry must not be called. Allowed calls should be between 8 a.m. and 9 p.m. So that's something we need to be aware of if we're making calls to people that we don't know. The exceptions, of course, are if we've got a personal relationship with someone, of course, we can call anytime. Established business relationship, as long as they've agreed that we can recall them, we're okay. Calling about a service originally provided, which in our case, you know, if we've already represented them, we could do that. And of course, if we have written permission to call. So if we were working with people that we don't know, we do need to be sensitive to the Do Not Call law. I'm going to show you a video which will just highlight where we are. And there have been some energy and activity on this particular topic in recent years. So hopefully I'll be able to cover that. So we'll go into the window to the law. This is off the National Association of Realtors site. Just give me a moment to pull that up. Well, this is about a 5-minute video. And just give me a moment to pull this up. I'll just have to bear with me one moment here. Let's see. Just have to do a different share. Where is that? Share. Just bear with me, guys. I'm slowly getting there. I have to just change my screens here. Okay, can you see the white screen now? Are there any nods on that?
With a
Okay.
blue line in it.
Yeah, this should work now. Can you hear that?
Yeah.
See that? Okay.
Hello, I'm John McClaskey, Senior Political Compliance Counsel and Director of Legal Affairs at NAR. Welcome to this episode of Window to the Law. In this episode, I will share with you an important legal update speaking to real estate professionals' ability to more freely use their cell phones for marketing purposes without fear of TCPA liability. On April 1st, 2021, the United States Supreme Court issued its long-awaited opinion in Facebook v. Duguid. In its unanimous decision, the Supreme Court not only overruled the Ninth Circuit Court of Appeals, but resolved the growing divide among federal courts by narrowly interpreting what constitutes an automated telephone dialing system, or ATDS, under the Telephone Consumer Protection Act, or TCPA. The court's holding made clear that the TCPA and its prior consent requirements only apply to devices that have the capacity to store or dial numbers, actually using a random or sequential number generator. Importantly, the decision has no impact and does not change adherence to existing do not call registry requirements. You may recall that the TCPA requires prior express consent when using an automated telephone dialing system to make calls or send texts to wireless numbers. Failure to obtain such consent can lead to legal liability and exorbitant penalties and fees. Prior to the Facebook decision, real estate professionals were oftentimes left wondering whether the use of their cellular phones to make individualized marketing calls triggered the TCPA consent requirements. A handful of federal courts, like the Ninth Circuit, created this confusion by interpreting the ATDS so broadly to include any device that could store telephone numbers, even if the device did not employ a random or sequential number generator. This broad definition implicated any smartphone used to make calls or send texts. The Supreme Court recognized the impracticality of such a broad definition and reasoned that, and I quote, expanding the definition of an auto dialer to encompass any equipment that merely stores and dials telephone numbers would take a chainsaw to these nuanced problems when Congress meant to use a scalpel, end quote. While the Facebook decision will likely quell caustic and costly class action TCPA lawsuits, don't get your hopes up too high yet. The Supreme Court's opinion left some ambiguity as to what constitutes capacity and use under the definition of an ATDS. As a result, certain calling technologies, such as predictive dialers and blast text, may be the subject of future litigation on this issue. Furthermore, the Facebook decision did not sit well with certain pro-consumer rights federal and state legislators who believe the TCPA should be broadly applied. Therefore, Congress and perhaps even state legislatures may consider new laws affecting marketing calls on the heels of the Facebook decision. That said, as a result of the Facebook decision, real estate professionals may, without fear of TCPA liability, use their cell phones to make marketing calls and texts without consent so long as they are not using a random or sequential number generator and are otherwise adhering to the do not call registry restrictions. Obtaining prior consent from those who are looking to call or text for marketing purposes is still highly recommended and remains the gold standard to protecting against TCPA liability. Check out NAR's TCPA and do not call resources to ensure your calling and texting activities are compliant. And thank you for watching this episode of Window to the Law.
Okay, let's see if we can get back to where we were. All right, I think I've got back to where I was. Okay, so let's just have a little chat about that video. I presume you've not seen that before, maybe you have. Anybody got any thoughts or comments or questions on that video? Or what did we learn from it? Let's see if we bring someone else in. Hey, Lisa, how are you today? I not spoke to you today. How are you?
I'm good. How are you?
Good. Have you seen that video before?
I have not.
Anything you learned from it or anything you'd like to share that may have been highlighted for you?
I probably need to check in the things that I'm doing because I have a lot of automated texts and stuff that goes out. And so I need to do a little research in what I'm doing to make sure it's in compliance.
Good. You're probably talking for all of us. So yeah. Thank you for that. Tell me about your texts. You say you do some auto texts?
Yeah, I run some Facebook ads and then some automated texts go out to keep in touch with that person until they're ready to talk to me. Okay. And so I kind of need to check into that and make sure it's correct.
Perfect. Anybody else like to comment on that? Let's see who we've not heard from. Well, Michael, we've not heard from you today. Are you still with us? Let's see if Michael can unmute and say hi.
Yes. It took me a minute.
How are you, Mike? I've not seen you for a while. I couldn't see you.
I've been kind of able.
How are you doing?
I'm doing well, other than I'm working on a cold.
Oh, you're working on a cold. Yeah, keep working on that. So tell me,
yeah, I'm not happy about it.
I know you've been in real estate for a while. Have you did you learn anything from that video that might be worth sharing or anything you'd like to highlight?
Yeah, well, I've seen it before, but all of it is obviously is so vague. It's, there's no way they're setting any precedents, and they have no way of finding out who they are that's calling. So it's like you can't control anything that you're getting on your phone, home phone, any phone. And now text, I just got one while we were doing this that I didn't request, and I have no idea who they are, but I'm getting texts now that you can't get stopped. So, it's a joke. You have these rules, but nobody applies themselves, and you get calls continually. And I just swear at them and hang up. So,
yeah,
that's all I have to say.
Well, thanks for sharing that. What are some of the things we just need to be aware of when we're working with marketing our services to people we don't know?
I think one of the biggest things I think, and I would do, is make sure you have some way to have them get off your list or whatever.
Yes.
Some texts and say put stop, and they should quit. But other than that, as long as you have a way for that person to say, hey, I don't want this stuff anymore, and then you abide by it, I don't see a problem.
Well, if they are on the national do not call list, then they could actually sue you if you continue to contact them and they can find out who you are. So what we need to be careful of in this industry is that we are trying to keep our records squeaky clean. Of course, if we are contacting people we know, we've already had a prior business relationship or we have permission with, then that's fine. But we're talking about people we don't know. I mean, you're sending multiple emails or texts to them. The first thing I think that someone has already highlighted, we need to have a way out for them, and unsubscribe on the email or a stop text option on the texts. Anybody else here have any experience where they've had to adjust their marketing platforms to accommodate the do not call law?
I have a question.
Yes.
Who you listen to here? The national do not call list. How do you get to that? Well, I'm not aware.
So that is a good question, and I understand you can get to it from that previous slide. I think there is a link on it. Let me see if I can pull it up.
It's really easy too. You can just Google the do not call registry, put your name and number on it. It's not going to stop all your calls, especially ones where they're spoofing another number. But those ones are hard to report because it's not a real number. So you can go to FTC's website to report unwanted phone calls and unsolicited phone calls, but you're just reporting a fake number, so it usually goes nowhere.
Yeah, so I think you'll find a link on this site here, this consumer.ftc.gov. There's a link on there.
About actually, if I call you.
Sorry, Michael, what did you say again? I missed that.
So yeah, I was thinking about if I want to call you, how do I find out if your phone number is on the do not call list?
Yeah, you can just go to the national call list and do a search. That's what the other gentleman was just talking about. Was that Josh who was speaking? Didn't see who it was. Or was it Brett? It might have been Brett.
It was Brett.
Yeah, Brett.
Okay.
At the same time, it's my understanding if you're calling things like a for sale by owner where they have put their home up, publicly listed, and you're calling them, that's responding to an ad, and that does not violate, from my understanding, any kind of do not call rules. Even if they are on a do not call registry, you're responding to their ad.
Correct. Yeah, you are right there.
And I have a question about the established business relationship. I get a lot of texts and calls from brokerages asking me if I would switch where I'm at, or people who want to buy homes that haven't been listed yet. Is that because we're licensed agents that allows them to do that, or are they not doing that correctly?
Now, they can call you because you're a licensed agent, you're part of the profession, you're part of the Utah State Realtors, and they can contact you. What they're doing, they're offering you another option or another service if you're interested. So they can do that. Any other thoughts or comments on this topic as we wrap this little class up here?
Going back to Michael's question and Brett's answer, do not call.gov. If you just type in your browser, do not call.gov, it'll take you right there.
Right. Very good. Thank you, Remy. I knew there was that link there. Very good. Good. Okay. Well, we've kind of got through a lot of stuff today. We looked a little bit about the fair housing laws, spent quite a bit of time on the Disabilities Act. We touched on the credit, the equal credit opportunity, the truth in lending. And we looked at those odd sort of acts, the Settlement Procedure Act and the Sherman Antitrust Act and the Uniform Commercial Code, the Environmental Protection Agency, and we finished up with that do not call law. I was just down the do not call, just make sure you understand what you're doing and you've got good records. And make sure you have an opt-out option if you are working with people that you don't know, so that you can respond if someone did challenge you on it. Anybody have any other questions or comments before I wrap this up? We will finish up just a touch early today. It's good to have you all with us today.
Point out, because I still see people doing this a little bit, but I think we're cracking down on it a lot recently. The way to avoid like the first half of that list of having any kind of issues is don't let your clients look at buyer letters or as a seller, or have them sign something that says if they are going to read somebody's buyer letter, that it's on them and not on you. Like Presidio has a form specifically that you can make them fill out so that you're not viable, or you're not going to be held liable for any of that. Because most of those things just come from agent or from the seller reading their buyer thing and then picking one or not the other because they read somebody's love letter.
Yeah, I do have a class where I show a video on the love letters. Best not to use them at all. I think this year they've cracked down on that particular area of, I guess, marketing. So, there will be some people that will start to be sued by using those, because ultimately often those love letters are clearly mentioning the sort of people we're working with or potential buyers. Maybe their ethnic minority or their religious views or their political views or whatever it may be. So yeah, trying to steer away from. Very good, Amber. Any other thoughts or comments or add tos? Perfect. Well, let's finish up this class. Lesley-Ann should come on in a moment and make sure you've got that